Okay, so this is another podcast on alternative methods of dispute resolution, more commonly referred to as ADR. Using the courts to resolve disputes can be costly both in time and money for people. People are therefore increasingly seeking and looking for alternative methods of dispute resolution. There are many problems with court hearings, such as the adversarial process, the fact that many cases have a lot of technical detail, the inflexibility of the courts, the imposed solutions by the courts, and also the publicity associated with court hearings due to the fact that any member of the public can view cases as long as they aren't to do with children or certain other cases. In terms of how often parties are encouraged to use ADR, judges in civil courts can actually ask the parties to consider using an alternative method, and this is stated in the Civil Procedure Rule 1.42e, which allows them to encourage the parties to use ADR but not force them. The fact that they cannot force them was held in Halsey v Milton Keynes General NHS Trust in 2004, where it said the courts do not have the power to force parties to try ADR, they can only encourage them. Interestingly, in the USA and Australia, they are prepared to force the parties to try ADR. In 2002, Hazel Jen stated that ADR generally results in a high level of customer satisfaction. Further findings in a continuing evaluation of the Civil Justice Reforms 2002 found that after a substantial rise in the first year following the introduction of the Civil Procedure Rules in 1998, there has been a levelling off in the number of cases in which ADR is used. In terms of the future of ADR, it is likely that it will play an increasingly important role in the resolutions of disputes. It is already widely used in the USA and other countries, so we are likely to follow suit. Now I will begin to discuss one of the four options of ADR, which is negotiation. But before I do so, I feel it is important to point out that the four options are not a process or route. You do not start a negotiation and move through to arbitration. Any party is free to start at any point, and yes, negotiation may fail, so the parties may move to mediation, but this is not obligatory. Negotiation involves the parties having an informal discussion and trying to sort out the problems themselves. There are many advantages to negotiation, mainly being that it's very cheap and it's also very quick. It can also be conducted in private, unlike the courts, which are, as we discussed, open to the public and therefore the media. One of the main advantages is that they can instruct solicitors if there's no success. They can continue to negotiate throughout the court proceedings, and this is why so many cases are often settled outside of court. Mediation is another method of ADR. It involves a neutral mediator who helps the parties reach a compromise solution. However, it is only suitable if the parties can cooperate. An example of mediation offered is the formalised settlement conference, which involves a mini-trial to a panel. There are lots of other mediation services, and there are a growing number of commercial ones. For example, the Centre for Dispute Resolution, which was set up in 1991. The typical cost of a mediator is approximately between £1,000 and £1,500 a day. In contrast, litigation can often cost over £100,000 or even over £1 million in comparison. Some mediation services are also free, for instance the West Kent Independent Mediation Service, which often deals with neighbour disputes. The latest idea is online dispute resolution, and a few examples of these include www.theclaimroom.com or www.mediate.com/ODR. The Family Law Act in 1996 placed a greater emphasis on mediation. It's to be encouraged in divorce cases, as the adversarial nature of litigation can quite often accentuate the parties' differences, which can make the process more traumatic for those involved, especially children. I will now discuss some of the advantages of mediation. One of the main advantages is that the decision need not be a legal one. It is more than likely based on commercial common sense, and is easier for companies to continue doing business with one another, and may include agreements about the conduct of future business between the companies. Another advantage is that everybody wins, partly, with mediation. Another advantage is that the Centre for Dispute Resolution claims that 80% of cases in which it is asked to act are settled, which is a very high number of settled cases. There are also multiple methods of mediation, and in addition the parties are in control, meaning that they can make the decisions and, more importantly, feel like they are making the decisions. In contrast, I will now discuss some of the disadvantages of mediation. There is no guarantee that the matter will be resolved, and it will then be necessary to go to court, which means additional cost and delay. Another disadvantage is that successful mediation requires a skilled mediator. A further disadvantage is the amounts paid in mediated settlements are usually lower than the amounts agreed in other settlements, / considerably lower than amounts awarded by the courts. I will now discuss the third method of ADR, conciliation. Conciliation uses a neutral third party who helps resolve the dispute between the parties. However, the conciliator will play a much more active role than in mediation. An example is the Advisory Conciliation Arbitration Service, ACAS, who can give an impartial opinion on the legal position. However, conciliation, like mediation, does not necessarily lead to a resolution. I will now discuss the final method of ADR, which is arbitration. This is where parties agree to submit their claims to private arbitration, which is now governed by the Arbitration Act 1996, and this applies only to written arbitration agreements. Section 1 of the Arbitration Act 1996 states that a. The object of arbitration is to obtain the fair resolution of disputes by an impartial tribunal without unnecessary delay or expense, and b. That the parties should be free to agree how their disputes are resolved, subject only to such safeguards as are necessary in the public interest. Around 10,000 commercial cases a year go to arbitration, which suggests that businesses are happy with the system. Agreements to arbitrate can be made by the parties at any time. Many commercial contracts contain a Scott v Avery clause, where the parties in their original contract agree that in the event of a dispute arising between them, they will have the dispute settled by arbitration. If there is an arbitration agreement, the Arbitration Act 1996 states that the court will normally refuse to deal with the dispute, unless a consumer claim where the dispute can be settled in the small claims track. Section 15 of the Arbitration Act 1996 states that the parties are free to agree on the number of arbitrators, and this may be a panel of 2 or 3 or just one arbitrator. If the parties cannot agree, the Act stipulates that one arbitrator must be used. The Act also states that the parties are free to decide on the procedure for appointing an arbitrator. There is also the Institute of Arbitrators, which provides trained arbitrators for major disputes. The court can be asked to appoint an arbitrator if there is no agreement. The arbitration hearing can take many forms, as the procedure is left to the parties. It may be paper only, or paper and oral. Witnesses can be called to give evidence, and this is again up to the parties. Great flexibility for the parties to decide on the date, time and place of the hearing also give many advantages to arbitration. A final decision is made by the arbitrator, and this is binding on the parties and can be enforced by the courts. The decision, however, can be challenged in the courts under Section 68 of the Arbitration Act 1996. There are several advantages of arbitration. Firstly, the parties may choose their own arbitrator. So, a technical expert, lawyer or professional arbitrator can be chosen. Secondly, an arbitrator can be an expert in the particular field, which is arguably better than explaining all the technicalities to the judge. Thirdly, parties have large degrees of flexibility as to the date, time, place and procedure of the hearing. Furthermore, the procedure is flexible and can be dealt with privately. It is quicker than a court hearing and usually much cheaper, and the decision is enforceable through the courts if necessary. In contrast, there are also many disadvantages of mediation. Legal aid is not available for arbitration, thus disadvantaging an individual in a case against a business. Secondly, an unexpected legal point may arise which is not suitable for decision by a non-lawyer arbitrator. A professional arbitrator's fees may be expensive, especially if it includes formal hearings with witnesses. Rights for appeal are also limited, and delays for commercial and international arbitrations can be as great as those in the courts. The National Consumer Council has reported that some are very slow. These disadvantages of arbitration have meant that it's drifting out of popularity. In terms of exam tips, the questions may ask you to discuss one or several methods of ADR. It then might ask you to discuss the relative merits of them. To score the highest marks, you should include examples of how ADR works and reference to well-chosen statistics to boost your answer.